Sanibonani ninjani molweni afsheni Tobelanda. Guys, today we are here with TLI4801, a tutorial letter 202. We have a techniques in trial and litigation, semester 2. And then, sorry guys, today is Saturday and I'm doing this video on the Saturday. I did this video later because I got this one early, but I was busy with other stuff also, so I did this one early. I'm going to do this one later. So guys, some people say that it's hard, some say that it's not hard. So let's read here. What I love is that they say that answer in this question paper are to be obtained from your prescribed material, which is your textbook, and then prescribed book, and then some additional sources that you have been given, and then you consult some references. They said that you may consult other sources provided that they are referenced, which is good. Which is good. Now let's start with the question. Mrs. Bright Lisedi is a businesswoman from Villa Villa, Limpopo. She runs a business that manufactures furniture. On 20 April 2024, she purchased raw materials from Oliver Woods Furniture, a furniture material factory in Pretoria, for an amount of 180,000. The material was delivered by Oliver Woods, and a copy of the invoice was handed to Ms. Lisedi, who then neglected to pay for the material within the 30-day period provided for in terms of the invoice. Despite repeated requests by Oliver Woods, Mrs. Lisedi did not settle the amount. Oliver Woods wants to sue Ms. Lisedi for the outstanding amount. The owner of the Oliver Woods approaches you for legal advice regarding the proceedings to be instituted against Mrs. Lisedi. So here the question, I think that doesn't make it sense. Saying that someone has purchased raw material, then you deliver. Then what are you owing if you purchased something? Unless if they said that she ordered raw material and then they deliver such a raw material and the invoice, and then she has not settled the bill. That I think that one makes sense, rather than she purchased. But I think that maybe they wanted to say, I don't know whether they wanted to put purchase. So let's look at the question number 1. Discuss this type of summons that Oliver Woods will use to recover the outstanding amount. So she wants to recover her outstanding amount. What type of summons she will use? So it's very much important that I educated you on this one. We have a combined summon which is unliquidated. Unliquidated is the amount which is determined by the court. For example, when plaintiff is injured, when you damage someone's car, when you have defamed someone, those amounts will be determined in court. So you have to go with a combined summon. Simple summon on the other side is liquidated. You claim when there's the amount to be claimed. E.g. is based on the contract. If I entered into a contract with you, then it means that you have to honor the contract. For example, Mrs. Lisedi, let's just say Lisedi ordered. Let's just say Lisedi ordered that material for 180,000. Of course, there was a contract. Then she fails to pay. Then she fails to pay such a kind of amount. Therefore, it means that she fails to honor the contract, which is the amount, of 180,000, which she must pay. So this will be based on the contract, because there's a contract that she must honor within 30 days, and then she fails to do so. However, we must not forget that we have another summons which we call provincial summons. Provincial summons claim only liquid documents. There should be a liquid document that proves that this person is owing, and this is claimed based on, for example, mortgage, and then some of the debt that the person has acknowledged, such as defendant's signature on the invoice. Then liquid amount, which is 180, is there. 180,000 amount to the liquid, which is there, which he must pay. So Lisedi on the other side, she has an invoice which has a liquid document which shows that she entered into this kind of contract, and then she entered into this kind of a debt. She signed an invoice which shows that she acknowledged the debt. But in the statement, they never made it clear whether she signed it. They never made it clear. So, for example, so for that, we can have to choose whether we can use the provincial sentence or the summon or the simple summons. That is the question that now we have. Should we go? Should we go for provincial sentence because it's applicable, or should we go for simple summons? Another issue. And then, if you can check here on the study guide, they said that SS attorneys decides to sue the defaulters by means of provincial sentence summons. The attorney's registered candidate attorney, who has recently passed civil procedure, believes that it will be more appropriate to use the simple summons procedure, which is of the two procedure is correct and one to use under these circumstances. Then the question was asking which of the two procedure is correct, one to use under these circumstances. Then they say they substantiate your answer. So when they give a feedback, they say that both type of summons can be used. The provincial sentence summons can be used because it's specifically designed for the institution of an action where the claim is based on a liquid document. Since the liquid document is evidence of an established monetary debt, the claim that arises also falls within the definition of a debt or liquidated claim. And then this means that in these circumstances, a plaintiff can choose which type of summons will be used. The fastest, most effective, and cheapest type of summon is in question of effect. In theory, it is provincial sentence procedure. So, in this way, guys, we are agreed that in this question, all of us, we are choosing simple summon. We are choosing simple summon for this one. So let's choose simple summon for this one. Let's choose simple summon rather than provincial summon. Let's go with simple summon because the question never made it clear about some of the aspects of the provincial summons. So let's choose the simple summon on this one. You must know that there was a question activity that says set sues Y for damages that is sustained during his Y sues Z for the payment of the contract price. What type of summons should Y use? Give reasons for your answer. And when the answer, they said that the simple summons, because the nature of the claim is debt or it is liquidated. The reason for this is that the contract price, monetary value of the claim, can be established by means of an ordinary mathematical calculation, and then they give such a thing. So this is how you must answer on that 4.1. By the way, you must follow the way that they've answered on that number A, and then if you want more, you'll come and read this on the study guide about the simple summon. The place that you must start is here. Where is that one? Yes, you come and read about a simple summon, then you summarize about this one, and then you answer like that one that you have seen the way we have answered. So yeah, we are done with this one. We are choosing simple summon. We are in agreement, all of us. Okay, they say number B, draft the summon chosen in above. So before you draft a summon, before you draft a summon, before you draft it, it is very much important to know the jurisdiction of the court. You will get 0 if you don't choose the rightful jurisdiction. Now let's look the amount that she's claiming. This person is claiming 180,000, which is the outstanding amount of 180,000, right? You know, in the study guide, they made it clear that currently, if you claim 200,000 or less, the matter falls within the jurisdiction of the district magistrate court. Currently, if you are claiming over 200,000 but less than 400,000, it falls on the regional magistrate court. However, if you are claiming more than that, of course, amount that is more than that, we go for high court. So the amount that we are claiming is 180,000. 180,000 is less than 200,000. Therefore, the competent court for this matter is district magistrate court. There are people every day who always write high court. You know, those people always have a mind that everything is for high court. Guys, check the amount that is claimed, and then you write the proper jurisdiction. You write the proper jurisdiction of that court, and not just think that everything is claimed from high court. So when they say draft the summons chosen in above, don't forget that once a summon has been saved and they made it clear that deliver the file notice to defend, they said at this stage, if the plaintiff has filed a simple summon, he or she will now file his or her declaration. Therefore, you are going to draft up what we call a declaration. Declaration is the same as a particular of a claims, right? Particular of a claims in a combined summon. In the simple summon, we call it a declaration. So let me show you an example of declaration so that you can draft up yourself. This is how you draft the declaration. Don't tell me that you don't have this document, because this document is available on your additional. You open this document, you follow the procedure. Don't forget that this one you must put only the district court when you start. Then you put the declaration here. Then you started to follow how they answered here. You follow the same thing that they were writing nicely. Then you do the amount, cancel of attorney for plaintiff. You put those things, then you are done. You see how they draft it, the declaration. You go and follow the same procedure. You follow the same steps, right? Then you finish. Don't tell me that you don't have this document, because it's on your additional resources. I hope that drafting will be easier because you'll be following the one that I showed you. Then number C, the owner of the olive woods requests your advice regarding a suitable ADR, alternative dispute resolution mechanism to resolve the dispute with Mrs. Lesedi. Expeditiously advise the owner of olive woods appropriate. So it means that you are going to discuss those ADR, all of them. You know, negotiation, arbitration, mediation, all of them. Then you choose which one is appropriate. Well, on your litigation prescribed book, there are methods of ADR, arbitration, mediation, negotiation, or determination by an independent third party, expect or doing nothing. Then you come and summarize arbitration, you come and summarize others, also all of them. You just come and summarize all of them. Just give a little summary about them, what they do, and then all of them. Then after summarizing all of them, then you choose which one will be appropriate for you, which one you think will be appropriate in that particular course of action, whether they must go arbitrary, or they must negotiate, or they must go for mediation, or they must seek an independent third party, or do nothing. It's on you. This one, you have a discretion to choose which one. But if it is me, I will have been choosing nothing but arbitration, because it's the one that I want my money. So if you are owing me, I don't choose anything but arbitration. However, I can even choose negotiation if we are going to negotiate in a way that you can settle the bill as fast as possible. So it will be another. Mediation to me is the waste of time, and then this one, after doing nothing, or determination, can be waste of time. But it depends on you. No, we can't tell you which one you're going to summarize. Give a little summary about this one. Then after that, you choose which one you think that is the correct ADR, right? Or it's on your page. Which page number is this one? Your study guide, your prescribed book has no page number. Unfortunately, you will just have to come here on this one. You'll find it yourself. It's your study guide anyway. It's a prescribed book anyway. So we are going to question 1.2. Discuss what you understand by the term heads of arguments. You know the rule, guys. The full video is on the join. Then you come and join. You pay 99 Rand. If you have already paid, it means that you will see the full video. Yes, on the current assignment, 99 Rand, you'll see this full video. And then you'll be able to know how to answer this assignment. So come and join, and so that we continue with that assignment. For those that joined, let's continue with the portfolio.